Hello everyone. This tutorial is called Salient Success, Turning First-Year Skills Papers into Effective Writing Samples. I'm going to try to keep it to about 10 minutes, and I'm going to dive right in. For those of you who are doing the early co-op, I think you'll find this helpful in converting your EMTALA memos into effective writing samples. Okay, so some basics about writing samples. First, when should a writing sample be provided? When will the writing sample get reviewed? Do not send a writing sample to an employer that's unsolicited. Only submit one when requested to do so by an employer. So be prepared, however, to bring a copy of your writing sample to an interview because they may ask for it then. But do not offer it unless they ask for it. The reason for that is every page that you add to your application process is more risk that an employer may spot an error in your writing. So less is more when it comes to an application often. These are not usually asked for at the beginning of the recruiting process. So given that they're often not asked for at the beginning of the recruiting process, you can glean a little bit more about what employers are looking for in writing samples. Because it usually comes after the initial interview has taken place, and after they've initially reviewed your application materials, it comes at a time when the job is yours now to lose, because you've already almost crossed the threshold into the law firm or the legal employer. So this is yours to lose at this point. So that puts the need to polish impeccably at an apex. So employers report that they use writing samples to distinguish between candidates to break ties as a barometer for quality of the work that they'll receive from you during your time there. And it could very well be the deciding factor on whether you're hired or not. It has been when I have hired law students before. So your reader is uniquely critical during a review of your writing sample. So you should be on a hunting expedition for anything short of perfection. Who will review your writing sample? Well, because of the function it serves, the writing sample has an extra critical audience, as I said. So assume it will be read by a supporting staff who is a professional proofreader and who circles all typographical and misspelling errors and misspellings with a red pen and passes it along to the hiring partner or attorney. If you just assume that, then you will approach the polishing process with the necessary critical eye. What will they be expecting with your writing sample? Well, they want clear, well-organized, polished, and engaging communication. They often cite the importance of brevity and simplicity as the keys to readability. They expect writing samples to accurately reflect the quality of work product that they will get from you. In other words, you have to be able to deliver at least the quality that you deliver in your writing sample. Do not create a writing sample that does not accurately reflect your abilities. This can happen when people seek outside assistance with writing samples. Where should be the sourcing of your writing sample? Of course, it should come from your LRW memos and briefs at this point, because that's the course that you're doing the most writing in. Avoid your group-related work, your project-related work for this class, unless you can guarantee you're the sole author of it. And even then, your memos are still a better source of writing sample, even though there are 29 other students who are potentially choosing an EMTALA memo. That doesn't matter. How much time will employers spend with your sample? Don't expect them to spend anything more than 10 minutes with it. But that's not a reflection on how much time it should spend you to create your writing sample. Pay special attention when you are polishing and revising to positions of emphasis within the document. I'm talking the first page, that's the biggest position of emphasis, of course. The last page, that's the second most prominent position of emphasis. The headings are all optical draws. The conclusions, your reader will read first, so those are important to get right. The umbrellas, comes on the first page. Those are very important to get a logical flow for. And your thesis roadmaps, because those show the reader that you have the ability to forecast your analysis to the reader and craft a clear and well-organized paper. So you should also fix any issues you have with readability and flow. If you are sensing some difficulty with flow between two sentences, take that as an indication that you need to make some changes. Don't settle. This should be the most polished document that you've ever produced, for 1Ls at least. Okay. So choosing your writing sample. Considerations for choosing your writing sample. Choose type before topic. The area of law in your writing sample doesn't need to be related to your desired practice area. It can be helpful. Like if you wanted to go into health law, if that was an interest of yours, and you were submitting to a health law attorney, then the health law attorney might read the EMTALA memo with added expertise, but also added interest. So it could help. But more important is to tailor the type of writing to your desired employer. So if you are writing or working for a litigator who does a lot of courtroom work, then maybe it's not an objective memo that you should be doing. Maybe it's a persuasive memo. Now, it's possible to turn your EMTALA objective memo into a persuasive piece of writing, but you don't have the skill set yet to do that because you haven't done persuasive writing yet. So I would avoid doing that at this point. So jurisdiction doesn't really matter. Don't avoid a federal case or federal matter or federal memo just because your intended practice area, intended jurisdiction is state. It would be possible to change the jurisdiction of the EMTALA memo to the First Circuit, but that involves a lot of research, and I intentionally chose the Ninth Circuit because the law was clearer than the First Circuit. So if you are tempted to change the jurisdiction, talk to me first, because I may know something about the jurisdiction because I've done a lot of research there. Short versus long assignments. Don't avoid the long assignments because they take more work to edit down. Your employer is looking for nuanced legal argument, and the nuanced legal arguments tend to come in the longer memos. So you should be showing the employer the most advanced level of writing that you can do, which are probably the longer assignments of the semester. You want to have confidence in your writing sample. You want to feel comfortable talking about the memo's arguments off the cuff in your interview, because they often use that as a vehicle for conversation. So the sample should reflect your ability. Don't mislead with a writing sample. It's not just for A papers. Don't avoid turning a writing memo into a writing sample because you were not happy with the assessment that you received or the feedback you received, or you thought your overall performance was lackluster. It could still be a good writing sample. And the end of semester papers may be more effective because that shows the culmination of your understanding and your learning in the course. So some general considerations for writing sample. Confidentiality. Now in the future, this doesn't apply here, but you may be using a real client matter in the future. Redact all of the identifying information. That doesn't apply here. Assume that your reader could be an expert in the area of law. So make sure that your references, your interpretations to the case of cases are reasonable, that your statement of rules are accurate, and shepherdize all case law before you submit it because the reader or who may be an expert may know of a case that just came down and you want to be able to talk about it in the interview, at least. And it probably should be in your writing sample. So this is interesting. Some sneaky edits are acceptable. So I learned this when I was crafting my own writing samples. Your reader is not an expert in the facts of our case. They may be an expert in the law, but certainly not with the facts of our case. So they will not know if you change any of the facts of our problem to make the writing sample more readable, or to make your comparisons more compelling, or to add more nuance to a counterargument. Assume your reader is an expert in the law. So for the EMTALA memo, this might mean you add a fact about the hospital's capabilities. Maybe you say that the policy required the nasal test. In fact, it didn't require it, it suggested it. Might there be information about how similarly situated patients were treated at match? Might Carlos have waited hours to make the comparison to Coria more compelling? So you can use your imagination to make your writing jump off the page with respect to our facts. Now, don't change the law, however, but our facts are malleable in a writing sample. So in terms of submission, you want to PDF your document. That should be your default unless they require it in a Word format. Word has the risk of transmitting too much metadata. If it requires Word, if they require Word submissions, you have to go into the preferences and you have to eliminate all of the metadata. You can Google how to eliminate metadata from Microsoft Word documents if you're curious. But a PDF does it. So all of your documents should be in PDF unless otherwise required. Less is generally more with a writing sample. There's more risk to more words. And your reader's attention is drawn away from billable hours, and they're really concerned about billable hours at many legal employers. So their time with your document is really short. Less is more. So I would recommend that for first year writing sample, it's generally less than 5 pages. And for an upper level writing sample, generally 5 to 10 pages. There's a lot of varying advice out there about page limit for writing samples. They're all over the map, but the reader generally has a tolerance of about 3 pages of reading without interruption. Then they start flipping around, they start losing their patience, they start rereading sentences. So I think 5 pages is plenty to show the depth of analysis that you need. 5, 6 could be okay, but generally 5 pages or less for first year writing samples. Now, so you've got to make some adjustments to your EMTALA memos if you're going to use them. There are some easy ones you can make. There's some ones of medium difficulty, and there are hard adjustments. Don't shy away from the hard adjustments. So cutting down the length is going to prove challenging, but I'm going to give you my suggestion here. There should be no unnecessary language. That's hard to do. And citations must be advanced. So you want to dazzle with your citations, not distract. They've got to be perfect. That's difficult. So we're going to work primarily with the difficult changes. Just with the easy ones, like make sure that you've defined your terms and parties correctly. You make sure you have a reference to the court and jurisdiction in the conclusion, the first conclusion, because many of you didn't say the U.S. Court of Appeals for the Ninth Circuit, and your reader needs to know that somewhere, that this involves Ninth Circuit case law. Otherwise, they're going to think, why are they citing Ninth Circuit cases? And the heading should be perfectly placed and spelled. I'll get to that in a few minutes. So other things you probably need to do is expand your counter arguments, ensure an even tone, objective tone throughout, and really make sure that your conclusions and topic sentences are perfectly framed. So reducing size. Here's what matters. Multi-issues matter. So you want your writing sample to have a multi-issue organization if possible. A single simple CREAC, just stabilization, for example, is not going to be as effective because it doesn't demonstrate nuance and an understanding of more complex organizational schemes. So that means either do screening only, because there were 2 CREACs in screening, or do 1 screening CREAC and stabilization. This also implies that you'll need to have an umbrella or thesis roadmap. So the second consideration, the potential to argue both sides well matters if you're using this as an objective memo. So you want arguments that you can have nuanced counter arguments for. And just a little secret, the rebuttal is one of the best places to dazzle the employer with your creativity and your intellectual aggressiveness. So really spend some time digging into how you're going to overcome or trump, there's got to be a better word for that, the counter argument. So this matters less, keeping your current hotspots. So what I mean by hotspots are the areas that are most compelling to read currently in your document. It's important to know this, and I wouldn't trust your own assessment about those hotspots. We're too close to our work to understand that. I would ask someone to read your document and identify the hot spots, the areas that are currently most compelling to read, and the cold spots, the areas that are least compelling to read. But don't let this guide what you cut. It's more important that you have a multi-issue organization. So don't let the fact that your current hotspots are all in one CREAC lead you to only include one CREAC. A multi-issue organization matters more. And I'm sorry, but sometimes your hotspots have to go. The places where we love the language that we use, sometimes they gotta go. Bye, Felicia. Just be mindful that when we edit around our favorite language, sometimes what results doesn't make sense. So we can reduce size in all of the stages of revision. In the revision stage principally, in the editing stage, and in the policy stage. So what we're going to work on is narrowing the legal issue. Imagine that I asked you to write the EMTALA memo not on whether there's an EMTALA violation, but whether there's a screening violation. This is akin to the involuntary commitment problem, with the first writing assignment of the semester, where I ask you only to analyze the issue of probable cause, the element of probable cause. Was there probable cause? Well, now imagine I said, was there a screening violation? If that's the issue, it cuts out a whole lot of text, and it focuses you in on the two screening CREACs. I would do that before cutting down any illustrations or factual comparisons. In fact, you should be building your most of you should be building your factual comparisons up. Employers look for those. So take a look at the rest of the slide, reducing size during the editing stage with more small-scale techniques, and during the polishing phase, things to do, things not to do. So let's take a look at an EMTALA memo I put together. This is comprised of a lot of students writing. So be mindful that this is student writing. So this is the initial opening of the discussion. This is language that I added. Here the conclusion was the court would most likely find that Mission Angeles Central Hospital match did not violate EMTALA. So some adjustments that I think all of you should make here is to include the reference to the court in the conclusion to orient your reader. I would define the EMTALA here by first referencing it as the Emergency Medical Treatment and Active Labor Act. And I would refer to Carlos as Mr. Hernandez. It's more formal. So just a few things in the opening conclusion. Now, back to narrowing the legal issue. So here, the issue here was whether there was an EMTALA violation. In order to address that, we need to address some very foundational rules about EMTALA, all of the elements of EMTALA. But if the issue is whether there's a violation of the screening duty, that brings us all the way up to the point of breach of one element. It doesn't require the regurgitation of all of the elements of the statute. It doesn't require, it doesn't require that. So we can eliminate a lot of language. Taking a look at one moment to this is a potential organizational structure using this new issue. Did Mach violate its screening duty to Carlos Hernandez? You'd start with a conclusion. Mach did or didn't violate the EMTALA screening duty because, some core reason. And the umbrella, you still need an umbrella because you have two analyses, both screenings. Basically here you're saying that when a participating hospital such as Mach breaches a duty to screen a patient, it violates EMTALA. So it's saying, it's the same thing as saying a police officer must have probable cause under the statute, right? It's not an untrue statement to isolate the element as required under the statute. So when they've got a duty to screen under the statute that they violate, that is a violation of EMTALA. To prove such a breach, the plaintiff may show cursory screening or disparate screening. That cuts a lot of text. So because it cuts out text dealing with the purpose of EMTALA, you might include that in a cover letter or a cover page, which I'll show you how to do. But make sure that you're laying the groundwork and you're not including too many rules here, because this cuts out a lot of rules. So then you'd have a thesis. You give your conclusion on each of the theories and your core reasoning. And then you'd have a cursory screening heading. There's no screening heading, just cursory screening, CREAC. Disparate screening, CREAC. I'm not sure whether you'd have 2 E's, 2 A's. Not sure whether you have dedicated counter, dedicated rebuttal. You may be able to condense a little bit. And then you could conclude on screening, because that matches your issue. And that's it. So that's my suggestion for editing the EMTALA memo. And some tips on polishing. Once you have the structure and the substance there, you should spend a great deal of time on polishing. Allow many days to proofread. Don't settle for verbosity. As I said in many of your comments on your EMTALA memos, short paragraphs, short sentences, short words. Don't settle on precision. Every word, every sentence should be toiled over almost to an obsessive level. Don't just rely on Microsoft Word for spelling errors and other typographical errors, because it doesn't pick up misuses of words or spellings that are otherwise correct but used incorrectly. Also, if you don't have Word's grammar and style checker turned on, you should do that in Word preferences. It's grammar and style, and it helps pick up any awkward sentence construction. So I would suggest doing separate citation proofreads for common problems with citations. Many of you still have work to do on citations. So some of you didn't track the first time you give a base citation for a case and recited the whole case again in full when you could have done a short form. So check for first appearance of base citations short form. Check for improper underlining of spaces, of commas. Make sure you have pinpoint pages for all citations and spot check them for accuracy, because the employers might. Check your usage of signals and parentheticals, your order of authority in multi-issue citations. Check omitting a case name in a citation when the case name appears in the text of the sentence. Check your spacing in reporters. And this is interesting. Check for curly versus non-curly quotation marks. Now, what the heck is this? So when we cut and paste quoted text from cases, text that includes quotation marks, when we paste them into Word documents, sometimes they create straight quotation marks, which aren't curly, they're straight. But that's different than a curly quotation mark. And the problem with straight quotation marks, and I've included a link here to Typography for Lawyers, which explains straight versus curly quotation marks. Here's a straight, and here's a curly. All of yours should be curly. The problem with the straight quotation marks is that they communicate metadata about your process of creating the document, because they indicate to the reader that you have cut and pasted that text from the internet. And you don't want to communicate that information. So you can just take, within your document, you can take if you see a straight, let's see if I see a straight one here. No, I don't really, but what you can do is if you see a straight quotation mark, find a curly one, cut and paste that one into the straight one, and you can make sure they're consistent. Yeah, I don't see any here. But they do indicate taking from directly cut and paste from the internet. So do separate grammar, punctuation, and style proofreads for all of the items that are in the editing document that I gave and posted on Twen. And this is so important. Do a separate proofread for your headings. When I read writing samples, I always look to the headings for error. I've seen some ghastly errors in headings. because Word does not check spelling and grammar automatically when text is in all caps. So you'll see a lot of problems in headings. The cover page. Your writing sample should have a cover page that includes your name, your contact information, your law school, and insert a synopsis of the assignment. It could be 1 or 2 paragraphs. It should have the date it was written in the semester of the class, any outside assistance received, that has to be there, regardless of the writing sample, if you received any outside assistance. Hopefully the answer is no, except me, and the TA or LF. Important redactions that you made, a statement of the specific legal issue, and any important contextual rules that you cut, and the basic factual context. So I've just gone ahead and created one that you could use freely, you could modify for your EMTALA memos. The attached writing sample is an excerpt of an interoffice memorandum that I drafted in 2017 as an objective writing assignment in my legal writing class. I wouldn't call it LSSC, I'd just call it legal writing. This sample was prepared solely by me based upon a previous version that I revised according to feedback received from my legal writing professor. This sample is limited to the discussion section of a memo. The issue herein is the likelihood that a hospital would be liable to co-executors of a deceased patient's estate for violating its duty to screen the patient under the Emergency Medical Treatment and Labor Act when the ER nurse took vitals using a respiratory screening card and the attending physician, without seeing the patient and only using the card, diagnosed the patient with H1N1 but failed to identify the patient's co-occurring diabetes. The purpose of the memo in the simulation was to assist the supervising attorney in making a representation decision. So I think it gives, this of course gives the narrower issue, which I think is the best way to go. Now you could also go other ways, and I'm happy to talk about just doing one screening and stabilization too, if that's your preference. Freely use this. I wanted to give you a head start, so I know that drafting new language can be difficult. Now, there are some thorny audience issues with writing samples. Gendered pronouns, what do you do? Offensive words, language, we don't have that luckily, but many writing samples do. Accuracy of the law, being sure you're being accurate can be thorny. And there are considerations about whether you should choose controversial topics such as abortion for writing samples. I'm not going to get into these today, but I'm happy to talk about these in the future. Some tips for impressing. Use sophisticated citations and use them correctly. This is impressive. A properly used CF signal or a properly formed explanatory parenthetical can be impressive to an employer. I look for them when I am reviewing writing samples. The specific side-by-side comparisons really matter. And including landings and a statement of the significance for our case really matters. This is a section that many employers will gravitate to because they want to see how you use the law to make your argument and how well you use the facts of our case. But importantly, it's also where your reader will flip to learn the facts of our case because you don't have a statement of facts. So they're learning about the facts there. So you've got to make that section compelling. Spend more time on your factual comparisons. Make sure they're thorough. Fully explore the counter argument and dazzle with a clinching rebuttal. If your sample is an objective document, give them an objective document. Make every sentence active if you can. And use signposts and segues to lead the reader through the analysis. Don't look like you're trying too hard. I can often tell when a student has looked at thesaurus.com or some analogous thesaurus to change up the word choice. Just rely on everyday English and just make it perfect. And I do suggest as a sort of long-term project that you create a new writing sample every year because your writing is improving dramatically and very quickly. And so every year in law school, you're going to want to have a new writing sample. That's it. Just if you have maybe your questions involve one of these frequently asked ones. Can a writing sample only have one point heading? No. We only include point headings when there are 2 or more headings. So if there's one point heading, you don't need to have a heading. So I already got this question from students. I submitted my writing sample already and noticed a typo. What do I do? Well, my basic advice, frankly, is stop crying over spilled milk. Hope the employer doesn't see it and ensure it never happens again. And some other employer pet peeves about writing samples. Failing to heed the requirements, such as page limits. Adjusting formatting to fit within the page limit. It's sneaky, it's unprofessional, it's obvious. Legalese or academic or judicial tone. You're submitting primarily at this point to practitioners, maybe judges, but they want to see practical, down-to-earth writing. Failing to underline the period in id will annoy many a law review alumni. And failing to include page numbers is my number one, because I often don't staple documents and I lose sight of where I am. Big pet peeve for employers. And that's it. If you have any questions, email me. I didn't heed my desire to create a short tutorial, so thank you for bearing with me. I hope this is helpful. Thanks.